Welcome back. Today we're diving into a Supreme Court moment, but maybe not the kind you'd expect. It's not about a big decision they made, but actually one they didn't make.
Right, it's about the court deciding not to take up a case, specifically Chanel E.M. Nicholson versus W.L. York, Incorporated.
Exactly. And what makes this interesting is a really powerful dissent from that denial, penned by Justice Jackson.
Yeah, she basically uses it to call out what she sees as a lower court getting the law fundamentally wrong on a critical issue for discrimination cases.
So our mission today is to unpack that dissent. We're going to look at this crucial legal difference between discrete discriminatory acts and what they call continued effects.
And why that distinction matters so much for someone trying to fight discrimination, especially when it comes to the statute of limitations, how long you actually have to sue.
We'll be sticking close to Justice Jackson's own words in her dissent, really getting into her reasoning.
It's a rare chance to see a justice directly challenge a lower court's interpretation like this.
Okay, so before we get into the legal weeds, let's talk about the person at the heart of this, Chanel E.M. Nicholson.
Sure. She was an adult entertainer in Houston, Texas, working at two clubs, Splendor and CoverGirls, on and off between 2013 and 2021.
And a key detail here, she had actual agreements, right? Like contracts.
Yes. License and access agreements with both places. And these weren't vague. They specifically said she could set her own schedule, decide her hours, and arrive and leave whenever she wanted without penalty.
So on paper, total freedom regarding her access and schedule.
That's what the agreement said. But Nicholson alleged that wasn't the reality at all. She claimed race discrimination was pervasive in both clubs.
Pervasive how? Were there specific policies she pointed to?
Yes, she alleged a very specific policy that the clubs were, and this is a quote, well known to severely limit the total number of black dancers. Why? Because upper management did not want too many black dancers.
Wow, that's pretty explicit. Was there anything backing that up?
Well, according to the dissent, yes. A former manager from CoverGirls apparently confirmed it was, quote, widely known and well accepted that black African-American girls generally are not given positions as dancers.
So common knowledge among staff, it sounds like.
And apparently the director of operations for the clubs even took away a manager's hiring power specifically because that manager hired African-American dancers.
Okay, so that's the alleged backdrop. How did this affect Nicholson personally, day to day?
She described a pattern. She said on a number of occasions, she'd show up to work and a door person or a manager would turn her away.
Because,
they allegedly told her, there were already too many black girls working. She actually estimated this happened about 3 times a week out of the 6 or 7 days she tried to work.
3 times a week? Just imagine trying to earn a living like that. Were there specific incidents mentioned?
The dissent highlights 2. In November 2017, at CoverGirls, a manager told her she couldn't perform because there were, again, too many black girls there. She eventually just stopped going to CoverGirls because of this treatment.
Okay, so that's 2017. What about the second one?
That was later, August 2021. She'd taken a break from dancing, then tried to go back to the other club, Splendor. A manager there also refused her entry, saying, not taking any more black girls.
And this time?
And this time, while this conversation was happening, Nicholson apparently saw a white dancer walk right into the club, looking like she was starting her shift.
Okay, so you have these concrete instances, these denials of work based on race. That brings us to the lawsuit.
Exactly. She filed suit in August 2021 against both clubs.
What was the legal basis for her suit?
She used a law called 42 U.S.C. Section 1981. It's a really important post-Civil War statute that basically says everyone has the same right to make and enforce contracts regardless of race.
So she argued the clubs were denying her that right, the same right Caucasian entertainers had?
Precisely. She alleged she was deprived of the same right to make and enforce contracts as Caucasian female entertainers.
And initially, how did the courts handle this? Did the claims move forward?
Well, 2 specific claims survived an early challenge, a motion to dismiss. Those were the November 2017 denial at CoverGirls and the August 2021 denial at Splendor.
And crucially, those dates.
Yeah.
They matter for the statute of limitations, right?
They absolutely do. The statute of limitations for this kind of claim is 4 years. She filed in August 2021.
So November 2017 is less than 4 years before August 2021. And August 2021 is obviously within 4 years.
Exactly. On the face of it, both claims seem timely. They fell squarely within that 4-year window.
Okay. Seems straightforward, but then the lower courts ruled against her.
They did. Despite those dates, the district court granted summary judgment against Nicholson, saying her claims were too late, they were untimely.
Untimely, how?
And the Fifth Circuit Court of Appeals agreed. Their reasoning was, well, a bit surprising based on standard precedent.
Was there logic then?
They looked back further. They said Nicholson was first denied access way back in 2014 at Splendor and 2016 at CoverGirls.
Okay.
And they decided that these later instances, the ones in 2017 and 2021, were, quote, merely a continued effect of those much earlier denials.
A continued effect, so like an echo.
Kind of. They said her claims started to accrue, meaning the legal clock started ticking way back at the very first denial, years earlier, because in their view, nothing had changed, and the club's discriminatory position had remained the same.
So because the discrimination was ongoing and consistent, later instances didn't count as new violations, is that it?
That's essentially the takeaway from the Fifth Circuit's ruling. If you knew about it years ago, and the policy is the same, then any new instance is just part of that old time-barred claim.
And this is where Justice Jackson takes issue.
Big time. She opens her dissent by saying the Fifth Circuit's holding flouts this court's clear precedents. Pretty strong language.
Okay, let's get into her argument then. She starts with the basics of that law, Section 1981.
Right. She reminds us it's about guaranteeing everyone the same right to make contracts as white citizens. Then she focuses on the statute of limitations rule, 4 years for these kinds of claims.
And the key precedent. You mentioned it earlier.
Yes, National Railroad Passenger Corporation v. Morgan, a landmark case from 2002. Morgan established a really important principle for what the law calls discrete discriminatory acts.
Discrete acts, meaning specific individual instances.
Exactly. Things like termination, failure to promote, refusal to hire, or in this case, denial of access to work on a particular day. For those kinds of acts, Morgan says the clock starts on the day the act happens.
Not when you first feel the pain or consequence, but the day of the act itself.
Precisely. The focus is the time of the discriminatory act, not the point at which the consequences of the act become painful.
So, applying that logic to Nicholson's case.
Justice Jackson argues it's simple. The November 2017 denial and the August 2021 denial were each discrete instances of discriminatory treatment. Each time she was turned away because of her race, that was a fresh discriminatory act.
An adverse and discriminatory action that happened within the 4-year window.
Correct. And each one is actionable on their own terms. They aren't just consequences of something that happened years before.
She contrasts this with the continued effects idea, right? Can you give that example again? It seemed helpful.
Sure. The dissent uses the example of a professor denied tenure because of race. That denial is the discrete discriminatory act. The clock starts then.
Okay.
Now imagine, years later, the university has a neutral policy. Anyone denied tenure is eventually let go. When that professor is later discharged under that neutral policy, they can't sue for race discrimination based on the discharge.
Because the discharge itself wasn't discriminatory, it was a neutral consequence of the earlier discriminatory tenure denial.
Exactly. The discriminatory act was the tenure decision. The discharge was just a continued effect. But Nicholson's case is different, Jackson argues, because each time she was denied entry based on the alleged too many black girls policy, that decision itself was discriminatory. It wasn't a neutral consequence. It was another instance of applying the discriminatory policy.
So it wasn't like the tenure denial, which was a one-time act with later neutral consequences. Here, the alleged discriminatory reason was present each and every time she was turned away.
That's the core of the argument, and she quotes precedent directly. The existence of past acts and the employee's prior knowledge of their occurrence does not bar employees from filing claims about related discrete acts so long as the acts are independently discriminatory.
Another kicker.
Each discrete discriminatory act starts a new clock for filing charges alleging that act. It seems pretty clear.
Does this relate to the continuing violation doctrine? I feel like I've heard that term.
It does, and Justice Jackson addresses that distinction too. The continuing violation doctrine is typically used for things like hostile work environment claims.
Okay, how's that different?
Hostile environment claims are usually based on the cumulative effect of many incidents, harassment, offensive comments, things that build up over time. Maybe no single incident on its own is enough to sue over, but together they create an abusive environment.
So it's about a pattern of conduct.
Right, repeated conduct. For those claims, the clock generally starts from the last act that's part of the pattern. And importantly, that doctrine usually helps plaintiffs by pulling older related acts into the timely claim.
Ah, so it brings things in, it doesn't push timely things out.
Exactly. But Jackson emphasizes this doctrine doesn't apply to discrete acts like Nicholson's claims. Her claims of being denied entry don't depend on proving a long pattern. Each denial stands on its own as a potential violation.
So the Fifth Circuit kind of misused or misapplied that concept.
Well, Justice Jackson argues their fundamental error, their central misstep, was concluding that just because the discriminatory reason, the alleged policy, was the same each time, the later acts weren't new violations.
Because the position had remained the same, as the Fifth Circuit put it.
Right. Jackson says that logic impermissibly inoculates recent discrimination. It basically suggests that if you discriminate consistently enough, eventually you become immune from lawsuits for the later acts.
That's a really concerning implication. It's like saying persistence pays off for the discriminator.
That's the danger she highlights. Her view is that the calculation should have been simple.
Okay, walk us through that calculation again.
Yeah.
Suit filed August 2021.
Right. First claim. The November 2017 denial at CoverGirls. The 4-year clock for that would run out in November 2021.
So filed in August 2021, it was well within the 4 years. Timely.
Correct. Second claim, the August 2021 denial at Splendor. The clock on that one wouldn't run out until August 2025.
Obviously timely, filed the same month it happened.
Exactly. So from Justice Jackson's perspective, based on established precedent like Morgan, the statute of limitations should have been no barrier at all, considering these specific claims.
And she felt the Supreme Court should have stepped in.
Yes, she argued the error was clear enough that the court should have summarily reversed the Fifth Circuit, basically, correct the mistake without even needing full briefing and argument.
So wrapping this up, we've explored this tension. On one side, the lower courts saying repeated, similar discrimination is just a continued effect of the first instance.
And on the other, Justice Jackson forcefully arguing, no, each discrete discriminatory act, even if similar to past ones, resets the clock if it happens within the limitations period.
It really highlights how these legal interpretations, these definitions, have huge real-world consequences for people seeking justice.
Absolutely. It's about access to the courthouse. Is the door open or closed when someone faces persistent discrimination?
So the final thought to leave our listeners with. What are the broader stakes here? If courts adopt the continued effects reasoning for repeated discriminatory acts, what does that really mean?
Well, it raises a fundamental question, doesn't it? If a discriminatory practice continues unchanged over years, does the law effectively grant it immunity over time? How does that square with the goal of anti-discrimination laws?
It could make it much harder to challenge ongoing systemic issues if the clock is always tied to the very first instance, potentially years or decades ago.
Exactly. It potentially limits the law's ability to address discrimination that isn't just a one-off event, but a persistent pattern, something to definitely keep thinking.